Hello, folks. Dustin Zarni here, Democratic Elections Commissioner in Onondaga County, and welcome to Commissioner in a Car. Today is Tuesday. It is August 27th, and this edition of Commissioner in a Car, we're going to talk about more litigation. You may remember last week I talked about early voting by mail. That early voting by mail litigation was finally done. It reached the appeals court level and has been proved constitutional in New York and thus is the law of the land. However, this week I'm going to be talking about two different types. Sorry, I heard somebody barking. I'm going to be talking about two other pieces of legislation that are happening. And unfortunately, they're not final, but both of them reached important stages over this last week. The first thing is another vote by mail lawsuit, again, instituted by the New York State GOP and their allies. And this is actually an older lawsuit. It actually predates early vote by mail. It actually has to do with the decision that New York made in 2021 for the 2022 elections to start counting absentee ballots, because that's what we had at the time. Absentee ballots as they came in, so those results were reported on election night instead of waiting 7 days after the election. And this was a very important piece of litigation, or legislation. Litigation, not so much, but the legislation was very important, something that I know many of us commissioners advocated for. And let me recap why this legislation came up and the history of this litigation. But first, before I do the recap, the bottom line on the ruling that came out was that this is a case that it was reviewed in the appellate court. It was a 3-2 decision, which is the second level of courts in New York, and it rejected the lawsuit entirely. What had happened is the New York State Legislature, after the 2020 election, saw hordes and hordes of lawyers, including here in Onondaga County, that came in to object to absentee ballots, since absentee ballots were not counted by New York law until 7 days after Election Day. What would happen is, if there was a race that was close, hordes of lawyers would come in and start objecting to absentee ballots on frivolous, sometimes no basis whatsoever, and cause a confusion to try to game an election. And because you already knew what the vote totals were on Election Day, you would come in and, there would be lawyers on both sides, but a lot of it came with the GOP that were coming in and just routinely objecting to Democratic registered ballots before they were opened on frivolous causes. So after 2020, when we saw this happen across the state in record levels, because it was a record level of using of absentee ballots in New York, and so many races could not be called on election night because of the sheer volume of absentee ballots that were out there. The legislature decided that they had to change the way New York counted absentee ballots, and they adopted models that we saw in other states where they would count the absentee ballots as they came in, as opposed to 7 days after the election. It used to be that if you put in an absentee ballot but went to vote in person on Election Day, that ballot would count, and thus we couldn't even open the absentee ballot until after all the history came in from Election Day to make sure that they didn't vote on Election Day and that you weren't counting somebody's vote twice. Well, they changed the law on that. They said that now if you put in an absentee ballot and it comes in, if you request an absentee ballot, you're not allowed to vote on the machines on Election Day. You have to vote by affidavit. And if you turn in an absentee ballot, that's the ballot that counts, as opposed to the affidavit ballot you might put in on Election Day. They also changed the way the objections were done. They did not allow outside objections from outside observers anymore. The only objections can come from Board of Election staff. You have bipartisan staff that is going through the absentee ballots and now the early vote by mail ballots, and they're the ones who can rule a ballot is not good or not. They also put a cure process in place, which means if a ballot was ruled not good, we would have time to contact the voter and let them know so they can choose to vote in person or send in another absentee or vote by mail ballot. And finally the law made sure and it emphasized that if commissioners disagree on absentee ballots, that if one commissioner agreed to count it, it would be counted, because then it wouldn't allow a commissioner to just hold open a whole bunch of ballots saying they disagree on it. So that was the legislation in a nutshell. There was a lot of other things in there, but that was the legislation in a nutshell. In 2022, very late in the calendar, a lawsuit was brought. It was called the Harkenrider lawsuit. There's Senator Harkenrider, of New York State Senator, it was the Armador, not Harkenrider, Armador lawsuit. Senator Armador brought it. It was brought very late in the cycle. I think it was in September. And it was after we had already had 2 primaries in 2022 where we were counting those absentee ballots in the way prescribed by the legislature, where as they came in, we would open them, canvass them, and then report the results on election night. And because that lawsuit got brought so late in 2022, then it was not... It was ruled laches. So laches is a legal term that says that it was brought too late to affect the election, that they couldn't rule on it. Counting had already started. In fact, there was some question for a couple of days. There were some Republican commissioners refusing to open ballots, waiting for the lawsuit to be to travel through the appellate court, but that was resolved pretty quickly. And this is during the general election last year. So it was late September. In 2022. So it was late September. It was ruled laches and thus no good. Then late in 2023's calendar, they waited a whole nother year and waited again till very late in the calendar to re-bring up this lawsuit. So not only did we count absentee ballots as prescribed by the legislature, we're counting them before Election Day in 2 primaries and a general election, but a 3rd primary in 2023 was also counted that way before this lawsuit was brought up. And in the lawsuit, they basically said that they understood that this would not be resolved until next year, so they knew that the general election in 2023 would be counted the way the legislature prescribed. And there was and so we did. And then we also did the presidential primary and the congressional primary in 2024 under the way the legislature prescribed. But in that time period, there was a ruling on it. And the thing is that the lawsuit itself kept getting delayed. And one of the reasons it got delayed is that this was a lawsuit filed in Saratoga County, and one of the clerks that was working on it with the judge in Saratoga County bragged at a GOP fundraiser that they were going to throw out the legislation just like they were going to do before, but ran out of time in 2022, and that story broke, and the judge had to recuse herself from the lawsuit because of her clerk. The clerk got fired, and then it got assigned to another judge, which delayed the initial ruling. Then the initial ruling came in by the judge, and it was mostly a victory for New York State, which means that the counting would continue the way that we've been continuing it. But there was one minor thing that could have turned into a major thing, that the judge said that The only thing that would be different is that if commissioners disagreed upon the validity of a ballot, those ballots would be held for the courts to rule on at a later point. The judge didn't prescribe a remedy there. It was just, or a procedure. It was just a ruling. New York State appealed that, and when the New York State is being sued by an election lawsuit and it appeals, then there's what's called an automatic stay. So that meant that we were continuing to provide absentee and now early vote by mail, because again, this is in 2024, ballots as we were going to count them as normal, waiting for the appellate court to render a decision. And just on I believe August 23rd, a 3-2 decision came down, and that decision basically, that small victory that the GOP had at the Supreme Court level, with the commissioners splitting and then those ballots being held for the judiciary, that has been removed. So now the appellate court, again in a 3-2 decision, so it wasn't quite unanimous at all, but in a 3-2 decision said that even that judgment by the Supreme Court is out of bounds, and that the New York State legislature has plenty of authority to propagate the rules in which elections are being held, and thus that is what happened here in this case. So it's been totally overruled. Now it is quite possible that the New York State GOP will take this to the Court of Appeals. I expect them to. This is what they do. But after the early vote by mail ruling just last week, which was a 5-1 ruling that basically said the same thing, that the legislature has every right to set the rules in which ballots are being counted, then, this is kind of along the same, for early vote by mail, this is kind of along the same lines for the canvassing procedures for early vote by mail and absentee ballots. So that was a big ruling this last week. And then another ruling that happened was, oh boy, there was a second ruling, and I don't have my notes in front of me. But there was another ruling that happened, but also an update on a previous podcast that I said about RFK. RFK was knocked off the ballot a couple of weeks ago in New York, and he was going to appeal that decision. And I did a podcast talking about that particular decision. But that podcast was, I went into it and I read the decision to you, and they were appealing that decision. But you may have heard that RFK has decided to withdraw or suspend his campaign in other, in some states, and in some states he's remaining on the ballot. In New York, he's not on the ballot as of right now, but he is appealing to get back on the ballot, even though he has suspended his campaign, or at least he hasn't provided New York with notice that he's dropping his appeal. So they are continuing to appeal that case. So we are waiting on that, and we're waiting on. Sorry, I had a technical difficulty there. Sorry, we're waiting on that appeal to go forward. So RFK is still on the ballot in New York. The other ruling that came just a couple of days ago is the ERA amendment, the Equal Rights Amendment. This was passed by the legislature, and when a constitutional amendment is passed by the legislature, there is the New York State Board of Elections has to come up with language to put it on the ballot as a question to voters. The amendment itself may be voluminous, maybe 50 pages long, but it has to be reduced to a single paragraph that voters can understand and make a decision on when it's on the ballot. And in fact, a new law was put in place that said ballot language proposals have to be in an 8th grade reading level. Well, the Republicans and Democrats on the New York State Board of Elections couldn't really agree on language for this amendment. Because they couldn't find a way to agree, they ended up with a kind of a compromise resolution that didn't have in there LGBTQ or the word abortion. We're not in the amendment, and even though the sponsors of the constitutional amendment on the legislature wanted that to be in the ballot language and wanted it to be understood at an 8th grade reading level, and I guess there was a test done of it by the acceptable measures of the test, and it was done at a 13th grade reading level. Well, some voters took the New York State Board to court on that, saying that the language is not correct. And the judge ruled and altered the language, but didn't seem to alter it in the way that the petitioners wanted. And also the New York State Board of Election, especially the Republican commissioner, said that the judge had no authority to rework and reword the language at all. And so we don't know whether that's being appealed at this date. I imagine it will be. I imagine that will be appealed on both, maybe by both sides. And remember, that's just a Supreme Court level. So that has 2 more steps to go. It could go to the Court of Appeals, and it could go to the appellate court level and then the Court of Appeals. So that is not over. So if people are wondering if the language for the ERA is final, yes, it is, because the Supreme Court has ruled on it, but that could be changed if the Court of Appeals or the appellate court sues on, or if they get the case and make him run it. So when will that have to be done? Well, quite quickly, honestly. Just like the RFK situation, although he's off the ballot right now, he could be ruled on the ballot by the Court of Appeals or appellate court, sometime between now and September 11th. September 11th is the day that the state board will certify the ballot for county boards to start mailing out ballots on September 20th. Anything after that, we'll get into what I referred to earlier in this podcast as the latches situation, where it's too late to actually affect the election because ballots are starting to go out. So my guess is that, we'll get some kind of movement on all of these cases next week after Labor Day, as the Court of Appeals or in the appellate court will fast track these election law cases, knowing the calendar is working, if they are appealed and if they are accepted by the appellate courts as well. So I just wanted to do a podcast updating you on these 3 different legal things, and let you know that New York is never simple. We're continuing on getting ready for the general election, but in many cases, there is still some question about what exactly is going to go on the ballot right now. So, in recap, as we said last week, early vote by mail is constitutional, and that's done. It's over. It went to the highest court. Early vote by mail is good. If you want to vote by mail in any election going forward, you can just request a ballot. Every year you have to request, or every election you have to request. So that's a hangover from last week. But on that same note, early vote by mail ballots along with absentee ballots can be canvassed before Election Day, and those results reported at Election Night. And frivolous objections from citizens are still not allowed. And we continue on with the same counting process that we've had now in 5 primaries and 2 general elections over the last 2 years. And then RFK is still not on the ballot in New York. He is appealing that, despite him suspending his campaign and supposedly endorsing Donald Trump. He is still pursuing that appeal. And then finally, the ERA lawsuit, there was a decision on it at the Supreme Court level that neither side seems happy at. So there could be an appeal of that, and the language on that still might be changed. And September 11th is our, that target of things have to be done by then for the state board to properly certify and meet the obligations that it needs to meet, and for county boards to start sending out ballots on September 20th. So that's all I got for you this week. Enjoy your week. Again, I'm running behind on some of my content. I've been pretty busy at the office with and also some other obligations that I can't tell you about right now, but I will tell you about in the future. I know there's a spoiler for you, or a teaser anyways. But I do plan on doing my Zarni seminar this week on how to register to vote, and my weekly wonk on the town of Clay this weekend. I plan on doing both of those during that time frame. So I'm hoping to have that done over the Labor Day weekend for you. So that remains my hope. Thank you very much for tuning in, and remember to go to DustinZarni.com. You can subscribe and get likes or get content and election news updates as this very busy election season progresses. Thank you very much, and enjoy your day. Bye-bye.